This is Colin O'Keefe of LXBN TV. Joining me today to discuss President Obama's recess appointments to the National Labor Relations Board is Seth Borden. Seth is a partner at McKenna Long Aldridge and author on the firm's blog, Labor Relations Today. Seth, starting off, can you describe the state of the NLRB leading up to these recess appointments and why they were necessary?
Sure. The National Labor Relations Board is the federal executive agency that administers the National Labor Relations Act. And that law is the law that covers most private sector employers and governs the relationship and the rights as between employees and their employers with respect to union representation and collective bargaining. The NLRB is often used in terms of the terminology to represent the broader agency itself, which includes dozens of regional offices and all of their staff that do much of the investigative work and some administrative work, the General Counsel's office, which has more of a prosecutorial function, and the ultimate decision maker within the hierarchy, the board itself. The board itself, which is tasked with having the final adjudicatory role, as well as a number of rulemaking and other administrative functions, is comprised of 5 members ordinarily. Traditionally, it's been 2 members from each of the prominent American political parties, the D's and the R's, and a 5th member from the party of the sitting president. During the late stages of the Bush administration, Senate Democrats blocked the president's efforts to seat additional members when the board had fallen below the 5-member complement, and as well put a mechanism into practice where they kept the Congress technically in what's called a pro forma session, never actually going into recess to preclude him from making recess appointments to the positions. And as a result, the board's membership fell below 3 members. There were only 2 members left for some period of time, members Liebman and Schomburg, one from each political affiliation as things would have it. The 2 members that were left continued to do the business of the board and issued decisions in hundreds of cases. In June of 2010, the Supreme Court said, not so fast. The act is fairly clear. You need 3 members to have a quorum, and that resulted in in invalidating a few hundred board decisions. And when President Obama took office, he filled the board. He nominated a number of people, and then through recess appointments made sure he had, for a while at least, a full complement. One of those appointments was a member, Craig Becker, whose nomination and appointment generated a fair amount of controversy. Mr. Becker was a former general counsel to the Service Employees Union as well as the AFL-CIO. When his term expired at the end of this past year, as well as a few other of those appointments, the board was back down to 2 members again. So just this past Wednesday, after having previously announced the names of the folks who he'd like to appoint to the board, President Obama announced the recess appointments of 3 members to fill out the full complement of 5 board members. And he did that on the same day that he announced the appointment of Richard Cordray, which also has generated quite a bit of controversy. There are a number of questions that have arisen that we'll talk a little bit more about, I'm sure, later, but the main, I guess, point of controversy here is that the president announced these recess appointments despite the fact that the Republican senators had been working with the House to keep Congress in this pro forma session to try to preclude these recess appointments.
Yeah, it's very interesting what's going on, of course, with the NLRB and the Consumer Financial Protection Bureau. Going back to the NLRB, What can you tell us about these three new appointees? Who are they?
The appointees whose biographies are covered in a little more detail in the National Labor Relations Board's press release, which we've linked to at our blog, are Sharon Block, who is most recently an undersecretary at the U.S. Department of Labor. She previously served as a congressional aide to the Senate Health, Education, Labor, and Pensions Committee, where she worked very closely with Senator Ted Kennedy. Interestingly, before that, she served as an assistant to former board chairman Robert Batista, who was a Republican appointee to the board. Richard Griffin, the other Democrat who was recently appointed, is most recently a general counsel to the International Union of Operating Engineers, and for a long time has held a number of legal positions for the Operating Engineers Union, as well as the AFL-CIO, lawyers' committees, and related pension funds. And Terry Flynn is currently chief counsel to the other sitting Republican board member, Brian Hayes, and before that had served in a similar role to prior Republican board members as well.
I see. And lastly, what do you see happening going forward? Are we going to see a lot of backlash over the fact that these were recess appointments? And how do you see the character of the board changing, if at all?
Well, that's the most interesting question, I suppose, of all of them. I think that what are folks to make of this? I think first and foremost, you're going to see the broader issue generate the most controversy and the most attention, and that is, coupled with the Consumer Financial Protection Bureau appointment, did the president have the right to make these appointments at this point in time? Were these appointments constitutional to begin with? And that is a larger, complex issue that will both generate litigation, as well as, like everything else that's happening right now, headed into 2012, a great deal of political controversy, I'm sure. And we'll have to see how those issues play out. There have long been arguments that the recess appointment power in and of itself is unconstitutional. But I think even casual observers recognize that throughout the course of the last several decades, administrations of both parties have used that power and used it fairly liberally to appoint people when the Senate is not acting on nominations. What makes this case unique somewhat is the pro forma session issue. Was the Senate in recess at all, and who decides when the Senate is in recess? And that's where you're going to find the constitutional crisis that folks are talking about right now. Does the president get to say the Senate is not really in session right now, or is that up to the Senate to decide? I think that once you get beyond that for labor law itself, you're not likely to see much change in the course that has unfolded the last several years in the day-to-day operations. The regional offices of the board will still operate. They'll still operate at their full complement. You're still going to have hardworking attorneys and investigators and officers in those offices taking in petitions, taking in unfair labor practice complaints, researching, investigating them, and making decisions whether to go forward. You're still going to have a general counsel's office that can assess cases and prosecute them, litigate them before administrative law judges. The question will come in the more complicated cases, in the more complex cases, or the cases that go through the ALJ adjudication process. What happens when a party seeks review of one of those? Obviously the administration's position is, and the board's position is likely to be, we have a sitting board that can hear these cases. But I suspect, much as will be the case with the first official action that the Consumer Board takes, if we get that far before a lot of litigation, the parties to the case are going to challenge the authority of of the agency to act. So I think that's likely to be where you see the impact. As far as the philosophical direction of the board, it will probably continue in the direction that we've seen the first couple of years of the president's term, and that is a more aggressive effort on behalf of the board to take an expansive view of the rights protected by the National Labor Relations Act and to look for novel areas where they can adapt the law and pursue some expansions of the interpretation of the law. The social media issue was sort of the initial area where they got a lot of attention on that last year, and then obviously this past year, the Boeing litigation was probably the biggest and the most politically charged example of that. I would hope that one of the takeaways for employers and employees and unions alike to come of this is that at some point folks take a step back and give a serious look at the impact that has been felt by the extent to which the board has become increasingly politicized. And that's not a new development in the current administration. It's the last several administrations. You know, we've seen somewhat of a pendulum swing with each new occupant of the White House and their appointees to the board. And I don't think it's necessarily in anyone's best interests, employers, employees, or unions, not to be able to count on some precedential value, not to have some reasonable expectation that decisions made during one administration are going to be overturned lightly in another. And you know, the past couple of years, we've heard a lot of talk about labor law reform, and unfortunately, you know, the overreach of the attempt to pass the Employee Free Choice Act, I think, obscured opportunities to look at other ways to help in this area. And many opponents of the Employee Free Choice Act that had a measured approach suggested looking at this issue specifically. And there probably are areas for bipartisan efforts to look at how do we ensure a fully staffed board that is not necessarily going to swing so drastically from administration to administration in its outlook.
That makes sense. It's going to be very interesting to watch and see what they do. Of course, you know, we've seen, like you said, social media be a hot button issue, and we'll see, you know, what will be the new hot button issues coming up. Once again, that was Seth Borden of McKenna Long Aldridge, and of course, Labor Relations Today. For more on this story, and honestly, you probably will have a hard time finding a better subject for NLRB news, be sure to check out laborrelationstoday.com. And of course, for more insight on this and other employment law issues, check out lxbn.lexblog.com as well. Thanks, Seth.
Thanks, Colin.